How you guys doing? This is the last Outlaw. Good to be here with you on a Monday afternoon. First off, I want to apologize because yesterday I was right in the thick of this edition of Bethea'S Byte Reloaded, and due to circumstances beyond my control, the way I have everything set up just kind of crashed around me, which caused the live stream to be abruptly ended, and that I apologize for. But I'm praying today is a whole different story that I can get all the way through. So, having said all that, welcome to the drama-free true crime destination. I'm glad to have you here on a Monday. Normally I'll be preparing to get set for this coming week, but there's no way I can do that without covering all of last week. So, but still, I'm glad to have you here. Again, I thank you for joining me. If you see and hear any and everything you like on this video, you're asked to like it, share it, subscribe to the channel, drop me a comment here on YouTube in the chat or in the community section. I'd love to hear from you. I mean, like part of the slogan, your voice is heard. And I'd love to hear your voice joining me right here as well. So if you want to join the live panel, it's open. All you gotta do is click the link to open, or copy and paste it to open a new browser window or tab, and we can bounce theories, ideas, all that great stuff off each other. I'd love to have you here. All right, for everybody in the chat, everything that is said here, unless we have something to prove otherwise, it's speculation, it's deduction, it's theory, it's opinion. It's not evidence, it's not fact, unless we have something to say different. Please, we don't need any kind of racism, homophobia, attacks on other people, spamming, and definitely we're not talking politics or religion here. Let's be respectful, okay? Yes, your opinions are welcome, but the attacks, If you don't like somebody else's opinion, you don't want to hear from that person, all you gotta do is if you're on YouTube, click on the three dots, find that person's name, click on it, click block. You'll never have to hear from them after that. Alright? Now, I got a feeling that with all the stories I'm covering on today's edition of Bethea'S Byte Reloaded, you're gonna see this trigger warning heavily. I'll throw it up there because I want to protect everything you see, everything you hear, but most importantly, I want to help protect your mental health. All right. So, like the last thing it says at the bottom, I'm sound like TV, but it's a fact here. Viewer discretion is strongly advised. Videos, I will definitely have this up as well, because we may be getting shots from the courtroom, updates from court TV. So yeah, I will definitely have this copyright disclaimer up. And speaking of court TV, all the articles that I'm sharing today, with the exception of what I just the exception of what I just told you earlier regarding the Elijah View search, that's coming from my good friends at the original True Crime Obsession, Court TV, your front row seat to justice. Shout out to that whole entire crew there. If you would like to help support me financially to keep this channel running, you got 3 different ways. You can hit me up at PayPal at EKB316, Venmo $EKB316, or Cash App. Venmo is EB the Last Outlaw, and like my good friend Brittany J from Allegedly a Brittany J would say, nothing's obligated, but it's always appreciated. And you can always get a hold of me all over social media, as I always tell you. I'm on Facebook at Bethea'S Byte Reloaded. I'm on X, formerly known as Twitter, at EKB316, but that's all caps. All caps. I'm here on YouTube at Bethea'S Byte Reloaded. On Instagram at EKB316, that's all lowercase. On TikTok at King of Hearts 316 2021. And you can also email me. The address kingofhearts316_09 at outlook.com. Alright. Now that we got the house cleaning all taken care of, let's get down to business. And we're gonna kick things off with a brand new trial that I believe is currently underway as we speak. This is the Fatal Family Birthday Trial, State of Florida versus Alexander Del Toro Jr. Alright, here's what we know. A Florida man is standing trial on charges he killed his mother while fighting with his father at a birthday party. The gentleman on the right side of the screen here, that's Alexander Del Toro Jr. He is charged with manslaughter for the death of his mother Cindy and battery for allegedly striking his father, Alexander Del Toro Sr. The trio, who all live together in Margate, had gone out to dinner to celebrate Alex Jr.'s birthday on December 14, 2019, when a fight broke out in the car on the way home. Police accused Del Toro Jr. of elbowing his father in the face while driving after he was irritated by his father's singing in the car. But Del Toro Jr.'s attorneys have painted a very different picture of the incident, saying that their client's elbow accidentally made contact with his father during a turn. The two began to argue, which escalated into a physical fight once the family arrived home. Once inside the house, the younger Del Toro lost his glasses and wound up pinned by his father against a concrete wall, according to the arrest records reviewed by Court TV. When Cindy tried to physically insert herself between father and son to break up the fight, police say Del Toro Jr. pulled out a gun and fired, striking his mother in the face. Del Toro Jr. claims that he had seen his father with a gun earlier in the evening and has accused the elder Del Toro of leaving his dying mother to hide it. Police never found a second gun in the house. Del Toro Jr.'s attorneys have said he was acting in self-defense and to protect his mother. The judge in this case had denied his stand your ground motion, which argued that Alex is and always has been scared of his father and has never raised a hand to him physically ever in his lifetime. Jury selection was supposed to begin on September 3rd. However, that morning that trial was moved to September 10th due to scheduling conflicts with witnesses. So there you have it, ladies and gentlemen. They'll start with jury selection tomorrow morning, September 10th, and I will be sure to follow this case as it goes all the way through from jury selection all the way to verdict, and if need be, sentencing. Next up, a Sarah Boone update. The last time we left Sarah Boone, she just got herself a brand new attorney, number 9. Now they want to delay the trial even further. But the judge said, nope, I'm not having that. A Florida judge refuses to delay Sarah Boone's murder trial, saying it's the defendant's own fault that her attorney has only a month to prepare. Boone was smiling as she appeared in court on last Tuesday for a hearing alongside her new attorney, the ninth to represent her on charges she killed her boyfriend Jorge Torres Jr. Torres was found dead, zipped inside a suitcase after a night of drinking. James Owens, who stepped in to represent Boone, asked Judge Michael Kranick to delay the murder trial until the end of this year or the beginning of 2025, citing a need to hire expert witnesses to pursue a battered spouse defense. Owens joined the case on August 30th because Boone struggled to represent herself after Judge Kranick ruled she had forfeited her right to an attorney. Owens said he planned to hire 2 forensic psychologists to serve as experts to bolster a battered spouse defense, but the deadline to file a notice for that defense is September 7th, this past Saturday. Owens said he has been unable to access digital evidence or go through the discovery that now sits in boxes with Boone at the Orange County Jail. Among the experts, Owens said he wants to hire Dr. Michael Bryan, who recently testified after diagnosing Marsha Thompson with battered wife syndrome in July. A jury found Thompson not guilty of first-degree murder in the shooting death of her husband. Judge Kranick refused to continue the trial, noting that the case had already been pending for 4 years, 6 months, and 4 days. Ooh. Did you guys get that? He had it down to the day. He admonished Owens that Owens was fully aware of the trial dates and deadlines when he stepped into the case, and said that Boone only has herself to blame for her previous attorney's withdrawals. Speaking outside of court after the hearing, Owens said that he had unsuccessfully attempted to negotiate a plea deal for Boone, but will move forward with the case despite being unable to secure a continuance. I'm going to have some help, Owens acknowledged. I'm trying to assemble a team right now. Owens also noted that he was not working pro bono on the case, telling the cameras, "Sarah owes me," quote unquote. Boone is due back for a motions hearing on September 26th, and her trial is scheduled to start October 7th. First off, ladies and gentlemen, I want to give the Honorable Judge Michael Kranick a huge round of applause. Now that's what I call that for standing for your principles. James Owens knew exactly what he was getting himself to the moment he said that he would be Sarah Boone's attorney. Again, I'm noting that this is her ninth. 9. And as for trying to delay the trial again, and the judge saying no, I have to agree with the judge, which is why I gave that round of applause. Sarah Boone, you had it coming. You had it coming. You only have yourself to blame. September 26th is the next hearing, and then October 7th, it's go time. Good luck, Sarah. You are definitely going to need it. Speaking of someone else who may need some luck, is Jose Ibarra. This is the man accused of killing Georgia college student Laken Riley. Ibarra wants some evidence suppressed, claiming some of the items of evidence was either seized or searched in an unlawful manner. Defense attorneys for the man accused of murdering nursing student Laken Riley are requesting a hearing to suppress evidence in that case. 26-year-old Jose Ibarra was arrested February 23rd for the murder of 22-year-old Riley, who was killed while jogging on the University of Georgia campus. In court documents reviewed by Court TV, Ibarra's defense claims 2 cell phones, Ibarra's social media accounts, and Google data, and ultimately his DNA were, quote, seized or searched in an unlawful manner, end quote. The defense claims officers unlawfully entered his apartment without a warrant on February 23rd, and Ibarra was detained by police in the absence of probable cause. The defense claims authorities obtained a search warrant after Ibarra was detained. The motion also claims the search warrants were not based on probable cause, overbroad, and was the fruit of the poisonous tree. A motion also raises issues with DNA testing and fingerprints collected in the case. They claim samples taken during Riley's autopsy did not exclude Ibarra, but also did not exclude another known individual associated in the case. An indictment charges Ibarra with 10 charges: malice murder, 3 counts of felony murder, kidnapping with bodily injury, aggravated assault with intent to sexually assault, aggravated battery, obstruction or hindering a person to make emergency telephone call, tampering with evidence, and peeping Tom. Ibarra is accused of attempting to sexually assault Riley, asphyxiating her, and seriously disfiguring her head by striking her head multiple times with a rock. Tampering with evidence charges for allegations he disposed of his jacket and gloves to conceal the crime. Ibarra is also accused of spying on a woman at an apartment at the UGA Village housing complex the day Riley was killed. Currently, he is scheduled to go to trial in November. Prosecutors are seeking life in prison without the possibility of parole for Ibarra, who previously pleaded not guilty to multiple charges in the death of Riley. Ibarra's attorneys have also filed a motion to move the trial from Athens-Clarke County due to media coverage, which prosecutors oppose. Oh, Amy just got here. How you doing, Amy? Good to see you. So he wants evidence suppressed. I don't think that's going to happen due to the fact that all this is critical evidence, which means anything against you at this point, you're going to be out of luck here, brother. You might as well just go on and face those 10 charges. You might as well just go on and face those 10 charges, man up, either come up with a good defense or take a plea deal and say you did it. But that's just me. I have my own theories about people taking plea deals. Next up, we're gonna go from one college campus to another, so to speak. We're gonna go from the University of Georgia to the University of Wisconsin after a man was arrested. Where a man was arrested after a University of Wisconsin gymnast is killed in an apartment. And I want to give Amy Crew a little bit of a shout out. She mentioned in a comment to me on the community section about the possibility of Chad Richards being the victim's boyfriend in the case. And my response was, if I remember right, was let's not assume things. Let's not assume things. Let's just wait. Let's just let the evidence come out and see what happens. Sure enough, Amy was right. Here's the break. A man accused of shooting and killing a star gymnast at the University of Wisconsin appeared in court on last Tuesday, where a judge ordered him held on $1 million bond. Whitewater police say 21-year-old Carol Welsh of Plainfield, Illinois, was shot and killed last Friday night. Welsh was shot I'd say last Friday. It was the Friday night before last. Welsh was shot multiple times in an apartment in the old Wisconsin Dairy Supply Company building. Police arrested a 23-year-old man, Chad Richards, who supposedly knew Welsh. Police referred several charges to the Walworth County District Attorney's Office, including first-degree intentional homicide, endangering safety by the use of a dangerous weapon, and disorderly conduct while armed. Police discovered there was likely an altercation between Welsh and the suspect before the shooting took place, but haven't offered any further information about what may have happened. In a message on the school's website, University of Wisconsin-Whitewater Chancellor Corey King offered more information about Welsh. She was majoring in management at the university's College of Business and Economics, and she was an accomplished gymnast. Welsh won the individual national title in the vault in 2023 for the school's team, the Warhawks. She also held 4 of the top 8 sports for the vault in the history of the school's program. King wrote, "We know the news of Carol's death is heartbreaking for our close-knit university community. It is a time when we are called upon to support one another, to process, and to grieve." In a statement by the gymnastics department, Welsh was described as a dedicated and supportive teammate with a big personality and a passion for motivating those around her. Ryan Callahan said, "For a lot of our community that is impacted by this is the first tragic event that they've ever had in their lives. A lot of it, this is the first time." Callahan is a University of Wisconsin-Whitewater athletic director. He's gotten to know Welsh during her 3 years as a Warhawk. "When you look back at the greats of whoever put on a Warhawk uniform or leotard specific to gymnastics, Kara's going to be on that list. One of the best ever." Welsh was a 2-time Division III All-American. She won the 2023 individual national championship in vault and helped lead the team to a runner-up finish earlier this year. Callahan said that her accomplishments are what they are, but the fact that she was such a wonderful person makes it even harder. Richards was due back for a preliminary hearing on this past Friday, September 6th. I'll be looking up that information to find out what that preliminary hearing was. Probably was for the formal charges that he will have, that Richards will have to face. Amy says that my memory is better than hers. Hey, I remember that comment specifically. And I remember that said, "Hey, I'm more of a wait and see guy." So I said, let's not jump to conclusions just yet, and let's see what happens, what evidence and what information pops up. And sure enough, yeah, he was the boyfriend of Carol Welsh. So great job on your part, Amy. All right, we're going to move onward. This one takes me back. This one takes me way back. A prison guard who had relations with Susan Smith opposes the killer mom's release. The woman who drowned her 2 sons is now up for parole in November, and her ex-husband vows to oppose her release. Now, I'm sure you may remember this particular case. As you can see from a shot here in this YouTube video, the lady on your right, and I use that term loosely in regard to her, this is Susan Smith. She took it upon herself because she was dating a man who himself said he didn't want children. So, she takes these two precious boys, drowns them, and then she gets caught in the biggest lie she could ever tell. Said a black man did it. Only for the entire nation to find out she did it herself. Now it's many moons later and she's up for parole. South Carolina mother who drowned her two toddler sons 30 years ago in a case that shocked the world is up for parole in November. The most recent person to speak out in opposition of Susan Smith's release is Alfred Rowe, a former prison guard who admitted to having relations with Smith. Rowe spoke exclusively to News Nation's Banfield, saying that Smith's prison record shows that she's not really learned anything besides how to do illegal drugs. Rowe also said he believes Smith has a lot of cleaning up to do before getting a shot at freedom. 3-year-old Michael and 14-month-old Alexander were still strapped to their car seats when Smith's car was found submerged in a Union County lake in October of 1994. Smith initially lied to police, saying she'd been carjacked while stopped at a red light by a black male who drove off with the boys inside. That never happened. Instead, a massive 9-day search for the kids took place, during which Smith made desperate pleas on television for their safe return. Smith's story began to unravel from the start. Investigators' suspicions that she was lying were revealed to be true on November 3rd, 2024, when Smith fessed up to having allowed her vehicle to roll into the lake. Smith claimed the murders were not premeditated and that she had been dealing with a mental health crisis. It was soon revealed, however, that she was motivated by an affair she was having with a wealthy older man who did not want children. At her 1995 trial, Smith's defense team tried to convince the jury that their client, in a bout of depression, drove to the edge of the lake in a suicide attempt, but that her body willed itself out of the vehicle. Smith, now 52, believes she spent enough time in prison. Her first parole eligibility hearing is coming up November 4. Smith reached out to her ex-husband in hopes of garnering his support. But if David Smith has anything to say about it, his former wife's sentence of 30 years to life will last as long as possible. Tommy Pope, the lead prosecutor on the case, spoke to Court TV's Julie Grant about Smith's pending parole hearing. As the former solicitor for South Carolina's 16th District, Pope argued in favor of the death penalty. A life sentence was eventually imposed, but Pope clarified that the jury was unaware that Smith would ever be considered for parole. They took the sentence at face value, believing life meant life. The sentence she received of life in 1995, the jury could not be told that life didn't mean life, Pope said. In other words, they were told, take life in your plain and usual meaning. Even even afterwards, the jurors were saying she will have to sit in prison. She will be remorseful about Michael and Alex, and she'll be there the rest of her life. One would think that. Smith was initially serving her sentence at the Camille Griffin Graham Correctional Institution in Greenwood, South Carolina. She was moved to Leith Correctional Institution in Columbia, South Carolina in 2000 after the two corrections officers were charged with having relations with her. Amy says, keep Susan Smith locked up forever. Mental health crisis, my eye. Hang on 1 second. Let me see. Where is it? Yeah. Amy, you know I have the I have my I have the live panel open, right? So if you want to bounce theories and ideas off, come on up. I just posted a link again for you. All right. Now, as far as my opinion on Susan Smith, I don't think she's learned anything in the last 30 years. I don't think she has any kind of remorse for what she did. In a way, she was like that old song from way back in the day, looking for love in all the wrong places. She was hoping to marry this man, probably. But his deal breaker was, like he said, he didn't want kids. All right, Amy. Maybe next time. All right. So anyway, like I'm saying, Susan Smith. She wanted to be with this guy so bad, but the guy didn't want kids. So she figured, eliminate her kids, she'll have a better shot with this guy. Here's a smart idea. If you want to be with this wealthy man, how about give your ex-husband full custody of the kids? You don't have to bother with the kids. You get the life you wanted. You save yourself on prison time. Everybody wins. Now, you're sitting behind bars. No, wait. You're up for parole in November. And when the question comes up, do you have any remorse for drowning Michael and Alex? Your attitude and what you say at that point is what's going to be the difference between you staying behind bars for the rest of your life and getting out free. And possibly, I don't see you showing any kind of remorse. Possibly, I don't see you showing any kind of regret. Possibly, I see you staying in prison for the rest of your life because you have absolutely no sense of what remorse is. And then on top of it, you blame and I'm going to use the word random here. You blame a random black man for kidnapping your 2 sons, which never happened. It never happened. And yes, I grew up following that case. When I found out 9 days later that she had drowned her children, I was just as stunned as anybody could be. But now, I'm no longer stunned because it's been 30 years. But I never forgot her name. I never forgot her face. I never forgot her case. I want to see her stay behind bars. Susan Smith is right where she belongs. That way, when they say that she's no longer a threat, she is absolutely no longer a threat. We'll see what happens in November, though. Next up, we have another mistrial on our hands. A jury was unable to reach a unanimous verdict for a former detention center worker accused of sexually assaulting an employee worker. In fact, now that I'm thinking about it, instead of me just talking about it, I am going to, as promised, flash this. Here's your copyright warning. Your trigger warning if necessary. And we're going to go right into the courtroom for this for this verdict.
I want to take you into the courtroom regarding Victor Malavit, the defendant in the broken trust abuse trial. This is the one in which the jury's been deliberating 8 hours. We understand perhaps they have a question. Let's go inside the courtroom.
Well, at this time, I've already asked you to further deliberate. Looks like nothing if I continue to ask you to continue to deliberate. So I'm going to be declaring, or I am declaring, a mistrial for all these charges. Members of the jury, I'm going to dismiss you from this case. I thank you for your service. If you don't mind staying in the room for a minute after I step off the bench, I can chat with you about your experience. It'll only be a few minutes, and I'll be right back out for you. So again, thank you so much for your time and deliberation.
All right.
All right, you just heard it. A mistrial has been declared. We knew that the jury had not been able to reach a verdict. They were told they needed to go back and continue their deliberations. They had deliberated 8 hours, 2 minutes. Let's go back into court.
The clerk will send out notice of next steps. We'll probably have a status hearing before we reschedule for another trial. Mr. Malavit, I'm going to remind you that you're still out on bail for these charges. Nothing's changed. We just don't have a verdict. The matter is still pending. And again, you'll hear from the clerk regarding next dates. Is there anything to add for the record before we conclude today?
No, Your Honor, thank you.
Okay. All right. Thank you so much for your time. You both sides did a very good job at trial. And we will see you soon. Thank you very much.
Thank you, Judge.
Court stands in recess.
All right, let's bring in our guest, trial and family law attorney Michelle Thomas. Michelle, kind of an interesting way that the court just described to the defendant, even though he's declared a mistrial on all counts. He said, this is still pending. You're out on bail. It's still a pending case. We'll do a status conference. We'll reschedule. It sounds like the judge has kind of assumed that the state's going to retry this man on these charges.
Good afternoon, Judge Ashley, and that's what stood out to me as well, that the court didn't really inquire of the state whether they intended to bring charges or whether they needed any time to discuss it. He just assumed and imposed that same type of expectation on this defendant. And so that's interesting to me, that apparently the court may have thought that there should have been a certain type of outcome and expects the state to go forward, but still it's ultimately up to the state.
Yeah, I agree with you. Now, 8 hours, 2 minutes. I think that that's not an unreasonable amount of time with the jury coming back twice to say, okay, it's a hung jury, meaning they cannot reach a unanimous decision. But I'm a little bit surprised. This juvenile detention facility, a counselor accused of rape, are you surprised that this was a hung jury?
I am, Judge Ashley, because the evidence seemed overwhelming. And let me just say that my heart breaks for this victim who may have to relive the horrifying accounts of sexual abuse that she endured when she was just a child, 15 years old, and tell the story again. I thought she was very compelling, very credible. There was nothing about her that was combative or that seemed as though she was trying to, just take the jury on a wild ride. She simply recounted what seemed to be the facts. The horrifying facts of what occurred and what happened to her. And so I do wonder what was going on in that jury room and what it was for at least one of the jurors that made them say they weren't quite sure and that they believed there was reasonable doubt. It could have been the monetary accusations. Certainly the defense, they tried to allege that she was doing this for some sort of monetary benefit because of the civil cases that were also pending contemporaneously. But I just wonder what it was in the jury room, because I thought she was very convincing and compelling.
I thought she was convincing and compelling as well, but I will say the defense during closing arguments really tried to focus on some of the inconsistencies in her statement, and they pointed out or focused on the fact that she did not report the abuse to the state police until about 6 months later after she filed a civil lawsuit. I don't know if that's what made a difference or not, but clearly not all of these jurors agreed that there should be a conviction for any of these crimes. A hung jury, mistrial declared, and we will wait and see at that status hearing that will be scheduled what the court does next.
And a special thank you to Court TV's Judge Ashley Wilcott and trial attorney Michelle Thomas for that coverage. The first criminal case linked to New Hampshire's sprawling child abuse scandal ended a mistrial after a jury deadlocked on charges against a former youth detention facility staffer accused of raping a teenage girl in 2001. I said the R word. My apologies, YouTube. Normally, I'm not internet friendly. It is what it is. I'm trying to be internet/YouTube friendly, okay? I should have read that as accused of sexually assaulting a teenage girl in 2001. 62-year-old Victor Malavet is one of 9 men charged in the 5-year-old investigation into abuse allegations at the Sununu Youth Services Center in Manchester. Though unlike the others, he worked at a separate state-run facility in Concord. After roughly 11 hours of deliberations over 3 days, the jurors said that they were deadlocked on the 12 counts of aggravated felonious sexual assault. Jurors had indicated that they were deadlocked 2 hours earlier, but Judge Dan St. Halier, if I'm pronouncing his name correctly, instructed them to continue. He declared a mistrial after receiving a note from the jury stating, after additional time with thoughtful deliberation, we are still unable to come to a unanimous decision on any charges. During the 4-day trial, Natasha Mansell, who was 15 and 16 when she was held at the facility in 2001 and 2002, testified that Malavet frequently arranged to be alone with her in a candy storage room, the laundry room, and other locations, and repeatedly sexually assaulted her. I remember having this gut-wrenching feeling that this was never going to end. This is never going to stop, and it's going to continue the same way every time, she testified. Malavet did not testify, and his attorneys called no witnesses in his defense, but jurors heard him deny the allegations during testimony of a state police officer who had been authorized to secretly record her interview with him on April 2021. The only relationship I had with her and all the kids was just a professional relationship, he said. Malavit's attorneys argued that Mansell made up the allegations in order to get money from a lawsuit. Mansell is among more than 1,100 former residents who have filed suits alleging abuse spanning 6 decades and has received about $150,000 in loans in advance of a settlement. It's all lies. Money changes everything, but it can't change the truth, defense attorney Jay Duncan said in her closing argument. Both sides declined to comment after the mistrial was declared. The judge said a status conference would be held before the trial is rescheduled. In a statement, Attorney General John Formella called the outcome disappointing, but said his office remains committed to prosecuting abusers. In the only civil case to go to trial so far, a jury awarded David Meehan $38 million in May for abuse he says he suffered at the Youth Development Center in the 1990s, though the verdict remains in dispute. Together, the two trials highlight the unusual dynamic of having the state attorney general's office simultaneously prosecute those accused of committing offenses and defend the state. While attorneys for the state spent much of Meehan's trial playing him as a violent child, troublemaking teenager, and a delusional adult, state prosecutors relied on Mansell's testimony in the criminal case. The Associated Press does not typically identify people who say they have been sexually assaulted unless they come forward publicly, as Mansell has done. During the trial, Mansell acknowledged that she denied having been sexually assaulted when asked in 2002, 2017, and 2019. She said she lied the first time because she was still at the facility and feared retaliation, and again in the later years because she didn't think anyone would believe her. It had been so long that I didn't think anybody would even care. I didn't think it would matter to anyone, so I kept it in for a long time, she said. Now, like Judge Ashley said moments ago, she may have to relive that trauma all over again. So we'll just have to wait and see when the next status hearing comes about and when that retrial will commence. Next up, we're moving forward. A judge rules a Colorado dorm shooting case can move forward to trial. Nicholas Jordan is the defendant in this case. He is accused of killing Sally Montgomery and one of his roommates in February. The judges ruled there was enough probable cause to send the alleged UCCS shooter's case forward to a potential trial. Oh, and for record, UCCS, that's the University of Colorado at Colorado Springs. Nicholas Jordan is accused of killing 2 people inside a UCCS dorm room earlier this year. A preliminary hearing was held Tuesday where prosecutors laid out more evidence in the case. Prosecutors called UCCS police officer DeMello to the stand. He was one of the first officers to arrive on the scene when the shots fired call came in just before 6 a.m. on February 16. Officer DeMello said he and other officers entered the dorm room around 6:10. He saw Samuel Knopp lying on the floor with abdomen injuries and Sally Montgomery lying on the bed with abdomen injuries. He said they both looked pale and had no pulse. Officer DeMello said a female witness was in another room. She said she heard a loud bang and a scream. The officer said a roommate living in the suite where the shooting happened said he heard about 9 gunshots. Detective Matt Kerr testified that Giancarlo Argueta told him that he, Knopp, and Jordan all lived in a dorm room suite together. Kerr said Argueta recalled issues living with the suspect, including him smoking marijuana in the room, playing loud music, and a lack of cleanliness. Argueta said in January a fight over taking out the trash ended with Jordan telling Knopp he was going to kill him. Kerr said the incident was reported to the university campus police. The detective said Argueta and Knopp both began applications to move to a new place on campus. On the morning of the shooting, Argueta told Kerr he woke up to the gunshots. He said he then heard footsteps running away. Let's see. I'm looking over everything just to get all this, jump right ahead in here. And the judge in the case said there's no probable cause to send the case forward. Jordan is expected to enter a plea during the next court hearing on October 25th. Now, previously, before this, he was found incompetent to stand trial. I guess now that is no longer the case. So October 25th, we'll find out where he stands as far as a plea, and we'll see where it leads to. Next up, in the files of It Couldn't Happen to a Nicer Guy, Chad Daybell's home is sold. The new owners say they plan to demolish it. The property was listed for sale in June, and the new owners say they plan to demolish the home and other structures related to it. Like I said, couldn't happen to a nicer guy. Chad Daybell's Idaho home has been sold to a nonprofit according to property records reviewed by Court TV. The Fremont County property is where the bodies of Tylee Ryan and J.J. Vallow were discovered in June of 2021, 9 months after they were last seen alive. It's also where Chad's first wife, Tammy Daybell, was killed in October of 2019. Chad and his second wife, Lori Vallow Daybell, have since been convicted of multiple charges in their deaths. Chad was sentenced to death, while Lori was sentenced to life in prison without the possibility of parole. Ahead of Chad's trial, ownership of the property was transferred to defense attorney John Pryor through a quitclaim deed. A witness at Chad's trials also revealed the transaction in court. Following Chad's conviction, the property was listed for sale in June. It was purchased for $350,000 by local nonprofit S.J. Healing Crossroads, Incorporated, and that's according to property records. KSL-TV reported the organization was started by a local couple who wished to remain anonymous. They were worried that Chad's home would be exploited as a macabre tourist attraction. We feel compassion for the families and the community, and we didn't want to see it purchased by someone whose intentions were inappropriate. There were rumors about how someone wanted to buy it and turn it into an Airbnb, and we just couldn't let that happen. That's according to the couple to KSL-TV. They're raising funds to demolish the home and other structures. A statement on their website says that S.J. Healing Crossroads provides community help and support for those affected by a traumatic experience or loss. We recently purchased the property formerly owned by Chad Daybell in Rexburg, Idaho. The funds donated will be used to remove the house and outbuildings. This will be a start in changing the property back into a positive place where such a tragedy occurred. What happens to sites of such tragedies typically garners public interest. In December, the home where 4 University of Idaho students were murdered was demolished. The suspect in their murders, Bryan Kohberger, is expected to face trial next year. In June, a 3-story building at Marjorie Stoneman Douglas High School in Parkland, Florida, was demolished. It was the site of the deadliest high school shooting in U.S. history. And since Alex Murdaugh's conviction, the Moselle property where he murdered his wife and youngest son has exchanged hands multiple times. So, like I said, in regard to Chad, as far as Chad Daybell is concerned, it couldn't have happened to a nicer guy. Killed his first wife and two of their children. Hid the bodies just so he can live a lavish lifestyle with his wife, who also had a hand in the murders. He's going to lose his life. He's lost his home. What else can I say? Couldn't have happened to a nicer guy. Next. Cold case murder possibly solved. Dana Shepard is charged with the sexual assault and murder of 19-year-old Carmen Van Huss, who was stabbed to death all the way back in 1993. And take a good look on the right side of your screen, guys, right here. This is your defendant, Dana Shepard. More than 3 decades after an Indianapolis teenager was found raped and murdered in her apartment, police have made an arrest. 52-year-old Dana Shepard was arrested in Missouri and charged with the murder and sexual assault of 19-year-old Carmen Van Huss in '93. She was taken from me when I was a freshman in high school, said Jimmy Van Huss, Carmen's brother. For my dad to find her after what was brutally done to her makes this day bittersweet, and I wish he was here to see it. Van Huss was found murdered inside her apartment on the north side of Indianapolis on March 24, 1993. According to court documents, Van Huss's father went to check on her after a co-worker said she didn't show up for work. He found her dead inside her home. A coroner's report reviewed by Scripps News Indianapolis revealed the victim was stabbed 61 times. Overkill much? For 31 years, the family of Carmen Van Huss has been searching for answers and justice. While nothing can ever replace their loved one, we hope that today's arrest brings them some measure of peace. We remain dedicated to bringing justice to all victims and will continue to pursue every lead, no matter how much time has passed. And that's coming from Deputy Chief Kendall Adams. Prosecutors said that in 2018 they used DNA and blood found in a trash bag at Van Huss's apartment to create a profile of the suspect. In 2023, detectives used genetic genealogy to identify Shepard as their suspect. Prosecutors say Shepard's DNA matches samples found at the scene and on the victim's body. Investigators say in 1993, Shepard lived in the same apartment complex as Van Huss. Shepard remains in custody in Boone County, Missouri, where he was arrested, and he's expected to be extradited to Indianapolis to face charges. 30 long years, and now they finally they may have finally got the person responsible. When you're diligent, results come. This police and all the other all others were diligent, and let me tell you now Smith is gonna face charges of first-degree murder. Life behind bars without the possibility of parole, maybe. Death penalty, maybe. We'll see how that works out when they go to trial. All right, here's a Richard Allen update. The judge ruled that attorneys representing Richard Allen will not be allowed to discuss Odinism or accuse others of the murders at trial. Already, Richard Allen's behind the 8 ball. Okay. So here's what I'm going to do. I'm going to give you a good rewind of this from Court TV, and I'll be back with my own commentary on it. But first, as promised, first the trigger warning, because this is tough enough. I mean, we're dealing with the deaths of 2 young girls and this monster who may be responsible for it. Here's a copyright disclaimer, because this is coming great from Court TV, and you're going to want to dissect every last second of this.
Following some new developments out of Indiana, the Delphi murder case, an Indiana judge, Judge Gull, has ruled that Richard Allen cannot use a third-party culprit defense strategy at his upcoming trial. This was under contention. Defense wanted to bring in these other theories.
Yeah, Odinism being one of them. Allen is charged with 2 counts of murder for the deaths of Libby German and Abigail Williams. Their bodies were found on February 14th of 2017. And we have someone here who can discuss that a lot more.
Yes, our senior producer, Barbara McDonald, she knows this case quite well and is noted from the beginning. Let's start with this latest ruling from Judge Gull, which seems to sort of fall in place with other rulings she has made. Defense pretty much striking out across the board when it comes to Judge Gull.
That's right. And basically there was a 3-day hearing in July and the first part of August that went over this and gave the defense an opportunity to come to court and provide evidence that there was actually admissible evidence related to these third-party culprits that they wanted to point at. And the judge said after that hearing that she was not satisfied that they had done that they had not presented anything that was admissible in court, showing that these people were at the scene or were not where they were supposed to be at the time. And so the judge is saying, no, you're not going to be able to bring any of this in. But the state's motion in limine was asking for a whole lot more than just limiting this third-party defense. And so some of the other things that the judge has said is not going to be allowed is any reference to even the investigator who looked into the Odinism theory. You know, that was a route that investigators had followed in the early days of the investigation. They said they didn't find anything that led them to believe that that was actually what was involved here, and so they stopped pursuing it. But those materials are what the defense has seized on, and they're not even allowed to mention the detective who looked into this and wrote that initial report about Odinism. His name is Todd Click. He is now retired, and his name isn't going to come in either. There's also not going to be any reference to the geofencing data, which the defense has indicated in filings, shows that there were other phones walking around the crime scene during the time that the girls were missing and their bodies hadn't yet been discovered. And so the judge is saying that also is not going to come into this trial. The other thing that I think is rather interesting is the state asked to prohibit any reference, and this is a quote from his filing, from Nick McClelland's filing, any reference to any prior bad acts or acts of any witnesses that plan to testify. And so it's going to be really interesting. There are obviously a lot of people who follow this case who think that this judge is biased against the defense and the defendant, Richard Allen, who you see there on your screen. He has been subjected to some very harsh treatment during his incarceration after his arrest. He is now out of the maximum security prison system and is in a county jail awaiting trial, which is supposed to happen next month. But Julia, I've heard you talk about this quite a bit, that these motions and these early decisions set everything up for the tone of the trial, and that's what's happening here. The judge in one motion is saying a lot of this stuff is not going to come in.
It certainly changes the landscape of what we are going to see at the trial. My question is, I know you've been watching all of these motions and pouring through them as they've come in. We've watched this case shift and change, but what's left? If the geofencing is out, if the third-party culprit defense is out for these defense attorneys, what do you think is going to be their angle at trial?
It's going to be tough. You know, there are a lot of attorneys discussing this case on social media who are commenting that this definitely sets this case up for an appeal. One even worded it that this ruling basically makes this first trial a practice run, which I know nobody involved in this case wants to see happen. The families of these poor girls, they've been waiting 7 years for justice. The arrest of Richard Allen came almost 5 years into this investigation. They are ready to move on to the next chapter of their grieving in all of this. So it's going to be really interesting. But, you know, Richard Allen's own words place him at the trails the day the girls went missing, around the time that they were missing. We don't know if there's any phone data, since it was 5 years later that he was arrested, that might show where exactly he was during those times. But right now it sounds like it's going to be his word against what the state has to offer.
And there's no Ron Logan, no Anthony Schatz,
no Ron Logan, no Anthony Schatz. Anthony Schatz was somebody that law enforcement asked people to help them with information on. He was catfishing girls in Indiana, asking for nude images. He has since been charged and sentenced to 43 years, unrelated to anything having to do with Abby and Libby.
In communication with the girls, right?
He definitely was in communication with at least Libby. And then Ron Logan was the man who owned the property where the girls were found, and he lied about where he was at the time they went missing. He was charged with probation violations. He spent a year behind bars and a year on house arrest. But, you know, these are people that law enforcement has never come out and said for sure that they are cleared. With Ron Logan, with Kegan Kline, they did say they could never place him in Delphi, but Ron Logan lied about where he was, and we still don't know exactly where he was at the time the girls were being killed, and that's another issue for the trial. Law enforcement has been unable to come up with a time of death, so it leaves a lot of questions about exactly who was where when, and when that crucial time period actually was.
And before I let you go, remind us the trial date is
October 14th through November 15th. It'll start with jury selection in Allen County, which is Fort Wayne, Indiana, and then the rest of it will be in Carroll County, where the crime happened.
All right, Barbara will be there covering for us, Court TV.
Barbara.
Thank you, Barbara McDonald. Let's bring back in Tad Thomas. Tad, your thoughts on this case and specifically this latest setback for the defense? Now, we should remind people that the defendant, Richard Allen, reportedly confessed multiple times to multiple people. There is some there for the state's case.
You know, that's right. But this is a devastating blow, really, for the defense, isn't it? And what people need to know is that the judges have discretion to keep out irrelevant evidence. It's not that the defense just gets to come in and throw anything they want at the wall. The judge has the right to narrow the proof to something that is a legitimate defense. Now, I agree wholeheartedly that, hey, you know, this case is going up on appeal. This type of a major ruling is certainly something that's going to go up if there's a conviction, whether there's confessions or not. But, you know, the judge has a right to narrow the evidence that's coming in, and the prosecution shouldn't have to, you know, fight ghosts and prove or try to disprove something that, you know, has no basis in fact. So it's a really interesting ruling by the judge, definitely going up on appeal. But, you know, judges, they really try to walk the line and allow the defense to have some leeway so that these convictions actually will be upheld.
Yeah, so she's keeping out the references to this cult, alleged cult, Odinism, that's been coming up in some of these motions by the defense. But the geofencing, we've seen lots of cases where the defense is able to show, hey, there were other people there, other people had access. That doesn't seem like it would be, according to this motion, something that would confuse the jury or mislead them on the facts. What's your thought on that versus some of the other things that the defense wanted to go after?
Right. On the other potential defendants, potential murderers, where there's evidence that they weren't there and there's just nothing that connects them to the scene. I understand the court keeping that out, but you're exactly right. Having the geo-tracking data and not having other answers for that, maybe the prosecution's already looked at that and the investigators have looked at what other phones are there, and they've tracked all of those people down and come up with some reason why those individuals should be excluded. I'd like to know more about that. But you're exactly right. That's objective data. It's not like it's opinion.
My thanks to Court TV anchors Ted Rollins and Julia Janae, along with the attorneys Barbara Dallas and Tom Tallis. They covering this thing with Richard Allen. Like I said right before we start, I showed that clip. His defense team and Allen himself are already behind the 8 ball. So the question is, what can be said and what cannot be said when it comes to his defense, because he can't use a third party defense. In fact, there's a lot of things he can't do. He can't use anything regarding the Odinism. Can't mention anybody outside of anything he has said or done. And on top of all that, they still have his confession. Man, when I say when you're behind an 8 ball and you're a murder defendant, that's never good. Alright, next up. Now this one is going to come complete with a video update for you. Special Prosecutor Kerry Morrissey has asked the judge to compel Alec Baldwin's defense to reveal when they learned about the evidence. That prosecutor is asking the judge to reconsider dismissing the charges against Alec Baldwin. So the motion was filed. Special prosecutor in New Mexico is fighting to have charges refiled against Alec Baldwin and has the judge to reconsider her decision to dismiss charges after a mistrial this summer. Baldwin was charged with involuntary manslaughter for the death of cinematographer Helena Hutchins, who was shot and killed on the set of their movie Rust on October 21st, 2021. The movie's director Joel Souza was also hit by the bullet. Baldwin was practicing a scene and was holding the gun when it went off, but did not pull the trigger. Hannah Gutierrez, who worked as the armorer on Rust, was convicted by a jury of involuntary manslaughter for allowing the live bullets onto the set. She was currently appealing her conviction while serving an 18-month sentence. Judge Mary Marlowe Summer dismissed the charges with prejudice against Baldwin on July 12 after his attorneys accused prosecutors of withholding evidence in the case. The evidence in question is several bullets that were given to investigators by Troy Teskey. Teskey, a former police officer, stored ammunition for Pell Reed, Gutierrez's stepfather, and a retired movie armorer. That ammunition came under scrutiny after the shooting, when investigators were trying to determine where the live rounds came from. Gutierrez's attorney had asked an investigator in the case, Corporal Alexandria Hancock, to collect a series of rounds from Teskey and send them to the FBI to be tested, but Hancock never did. When Gutierrez's trial ended and Teskey had not been called to the stand, he took the rounds that remained in his possession and gave them to the Santa Fe County Sheriff's Office. Carrie Morrissey wrote in her motion, "The fact that Mr. Teskey turned over live rounds with the same characteristics as the live rounds found on the set of Rust that can be purchased at any gun store 2.5 years after Ms. Hutchins' death is immaterial to the case against Mr. Baldwin." In their motion to dismiss, Baldwin's attorneys argued that his rights to due process were violated when the prosecution failed to hand over key evidence. But Morrissey said it had never occurred to her that the rounds could have been relative to the case. There was no cover-up because there was nothing to cover up, Morrissey said in the motion. Morrissey also asked in her motion for the judge to compel Baldwin's attorneys to provide a description and all documents related to when and how they learned of the Teskey ammunition, accusing the defense of waiting to raise the issue during the trial as a tactical move. The bullets in question were not key to the prosecution's case, Morrissey said in the filing, noting Mr. Baldwin still handled his gun recklessly in violation of his own union safety bulletins and New Mexico law. The case against Mr. Baldwin was solely based upon his actions when the gun was in his hand. On September 5th, Judge Summer denied Morrissey's motion with prejudice, noting that the 52-page filing exceeded the 10-page limit. So they want to reopen. So they wanted to reopen the case. Here is, I'm gonna go ahead and hit this again. This is the copyright disclaimer, and as that's posted up here, I am going to set up this quick 52-second report from Michael Ayala regarding whether Alec Baldwin's case will be reopened or no.
We have more breaking news for you, this time out of New Mexico in the Rust shooting case involving actor Alec Baldwin. Deadline reports that efforts to reopen the case have failed. Baldwin was in court when his manslaughter case was dismissed in July because the state failed to disclose critical evidence to the defense. Special Prosecutor Carrie Morrissey submitted a 52-page filing to the judge trying to get that overturned. But Judge Mary Marlowe Summers said the filing was far too long and should have been, by law, 10 pages long unless permission was granted for more, which she did not have. Baldwin was charged after cinematographer Helena Hutchins was shot and killed as Baldwin rehearsed a scene for the movie. The film's armorer was convicted and sentenced to 19 months behind bars, and an assistant director took a plea deal after that shooting in 2021.
And there you have it. The case will not be reopened. It has been dismissed with prejudice. And for all of you legal eagles out there, just a reminder: if a judge dismisses your case with prejudice, that means that case can never be tried again. Score one for Alec Baldwin. All right. Next up, in a story that rocked the country, a 14-year-old kills 4 at a Georgia high school. And that's only the beginning. Once again, first off, trigger warning, because this could really mess with your mental health. I'm going to keep up a copyright disclaimer for this story as well. Let's go to this press conference regarding that.
Good afternoon. I am Chris Hosey, Director of the Georgia Bureau of Investigation, and we wanted to come back this afternoon and present you with a little more of a timeline of the events that have taken place here today and what we know up to this point with the investigation. At approximately 10:20 a.m. this morning, the Bexar County Sheriff's Office received alerts about reports of an active shooter and radio traffic from school resource officers concerning the same concern, or having the same concern. Within minutes, law enforcement was on scene, as well as 2 school resource officers assigned here to the school who immediately encountered the subject within just minutes of this report going out. Once they encountered the subject immediately surrendered to these officers, and he was taken into custody. Additionally, what I want you to know as of now, there are 4 individuals who are deceased from this incident, 9 that have been taken to local hospitals with various injuries. Of those that are deceased, 2 are students and 2 are teachers here at the school. The priority right now for us within this investigation is to gather all the facts, to make sure that we're accurate with it, because this is a murder investigation. As the sheriff mentioned earlier this morning, the shooter is in custody. His name is Colt, that's C-O-L-T, Gray. He is a 14-year-old student here at the school, G-R-A-Y. He is a 14-year-old student here at the high school. Again, he has been taken into custody. He will be charged with murder, and he will be tried as an adult and handled as an adult. We're coordinating these charges and obviously this investigation with District Attorney Brad Smith, who is the District Attorney for the Piedmont Judicial Circuit here. Since earlier this morning we talked with you, and since the incident occurred, numerous interviews have been taking place through our investigation with students, faculty, as well as any other witnesses that we could identify. Law enforcement had a very, very swift response to this incident once the incident was determined that there was a concern here. Those resources, whether it was in that response or throughout this investigation to assist, came obviously from the sheriff's office here, from other local law enforcement agencies, state law enforcement agencies, and the federal law enforcement agencies as well. To include, not to be left out, multiple EMS personnel, multiple fire personnel, and agencies. Those agencies responded here as well today, and I am extremely grateful, as I know the sheriff is, for that quick response and the partnerships of working here together with what all is going on. Currently, from the investigative perspective, we have crime scene agents and other special agents from the GBI, from close to a dozen of our different work units from across the state that have responded here today to work on this investigation, again, collecting evidence, conducting interviews, and so forth. I do want to pass this along, that if anyone has any information that wants to be passed on concerning this investigation, that they can do that anonymously at our tip line at 1-800-597-TIPS or 1-800-597-8477. They can also report this on by downloading the See Something, Send Something app. They can be done by Android or Apple phones, either one. If they need to report any tips concerning this investigation. Let me close out before I turn this over to the sheriff and let you just remind you that this is still a very active investigation. There is still a lot that is very fluid. There's still a lot of interviews to be conducted that will continue on into the night, as well as crime scene work and collecting and gathering evidence. But what is more important for me to mention here to you is my heartfelt sympathy to the parents, the students that were here today, regardless of where they were in the school. This has got a great impact on them as well as on this community. My thoughts and prayers, along with everybody standing behind me and every law enforcement agency in this state, and many, I will tell you, around this country, they are in our thoughts and prayers. And we will continue with that. We ask for your patience as we continue through this, and we'll continue to try to give you as many updates with information as we can to keep you informed. But thank you for being here. I'm now going to turn it over to Bexar County Sheriff Judge Smith. Thank you.
All right, we do have to step aside here, take a break. We'll hit the pause button. We'll hear everything that the sheriff has to say. Just want to say it's an ongoing investigation by a number of the state, federal, and local agencies, and they're really just trying to get all the facts at this point. We'll come back with that sheriff's part of this press conference when we return. So keep it here on Court TV, your front row seat to justice.
Tonight on Closing Arguments, new developments in the Delphi murder case, the long unsolved murders of 2 teenage girls. We'll unpack the latest legal maneuvering as our experts weigh in.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
He's the man who beat me up for 5 years.
2 celebrities reveal their turbulent relationship to the world.
Go ahead. Hit me. Victim to Verdict with Ted Rollins. New season premieres Sunday night, 8/7 Central.
Only on Court TV.
Hey.
Welcome back. We want to get you back to Winder, Georgia, where Appalachian High School is located. There was a school shooting that happened this morning. There's been a presser, and the GBI director first addressed everyone to explain that they are investigating. It's an active shooter. The shooter's in custody. CNN reporting only 14 years old. He actually confirmed that and said he will be tried as an adult. Law enforcement on the scene very, very quickly to take control of the situation. We want to go back in now because we understand the sheriff, who's Judge Smith there, is going to be speaking.
Good afternoon. I'm Sheriff Judge Smith of the Bexar County Sheriff's Office. I never imagined that I would be speaking to the media in my career over something that happened today, the pure evil that happened today. I cannot thank the people behind me for the support they give me today, to give this office and give this staff. This is home for me. I was born and raised here. I went to school in this school system. My kids go to this school system. I'm proud of this school system. My heart hurts for these kids. My heart hurts for our community. But I want to make it very clear that hate will not prevail in this county. I want that to be very clear and known. Love will prevail over what happened today. I assure you of that. It is very early as to what happened. Governor Kemp reached out to me and has provided me every single resource that he has to make sure justice prevails. I don't know why it happened. I may not ever know. We may not ever know. But I ask that you and our community lift up our schools, lift up our public safety, and that, again, we do not let this hateful event prevail as to what happened today. I want to thank the surrounding agencies and counties and cities and state and federal authorities that have come and provided us, because they prevented a lot of more tragic events from happening. Continue to lift up these families, continue to lift up our students and our kids, and know that love will prevail. At this time, I'm going to ask Dr. LaDuff, our school superintendent, to come and speak on behalf of the school.
Good afternoon. I'm Dallas LaDuff. I'm the superintendent of Bexar County School System. I want to thank the Bexar County Sheriff's Office and all of our law enforcement partners for their swift response today, along with that of our staff. I'd also like to thank our community for their response and patience as we work to reunify the students with their families here today and secure the rest of our school campuses. Our schools will be closed for the remainder of this week as we cooperate fully with law enforcement to get answers to the many questions that we all have about this incident here today. But as we are closed, our central offices will remain open, where we will have grief counseling available for our community every day this week and thereafter as we support each other through this terrible event. In closing, I just want to say to our community, as a school system, we are here for you, we support you, and we are ready to get you any support that you may need as we grieve through this together. Thank you.
Sheriff, if you're saying hate will not prevail in this community, are you investigating this as some sort of hate crime?
Well, shortly, if someone decides to take a firearm into a school where kids are given an education or entitled to an education and want to harm others, to me, it's hateful.
Sheriff, can you talk about the initial interaction between whoever was able to stop the shooter? Can you describe that to us? How did it go down? What exactly happened to us?
Obviously, the shooter was armed, and our school resource officer engaged him. And the shooter quickly realized that if he did not give up, that it would end with an OIS, or an officer-involved shooting. He gave up, got on the ground, and the deputy took him into custody.
Sheriff, any idea how the weapon got inside the school? Was there any warning that this was going to happen?
Not that I'm aware of. Again, very early, and we're still looking into that, whether or not, or how he obtained it and how he got it in the school.
Has anyone talked at all with his parents or his family to learn more about what led up to these moments?
We have.
Any information you can share?
No.
What kind of weapon was
It seems like you have a large Hispanic population. Have you been able to communicate with the people in their language to make sure that everybody knows what's happening?
Yes, sir, I have. The school and our office has people that speak in Spanish, and they have spoke to those folks as well. Yes.
How is
Sheriff, is the shooter
Sheriff?
speaking with the law enforcement now?
Sorry.
Is the shooter talking? Is he saying why?
The shooter was interviewed, and he was speaking with our investigators earlier, along with the GBI.
How is video surveillance? How does that help you, Sheriff?
It is helping our investigation.
Sheriff, is this...
Reports of threatening calls perhaps made to the school prior to the shootings that
None that I'm aware of.
were all 9 injured victims shot?
In some capacity, yes.
Sheriff, can you tell us about the 2 individuals deceased and was one targeted?
We don't know of any targets at this point.
What kind of weapon was used? Have you identified the weapon?
We have not identified that at this point, no.
Sheriff, is there a connection?
This is the last question I'm going to take.
Sheriff, is there a connection between the shooter and the victims?
None that I'm aware of.
I know that you have a lot of questions about the student and that we mentioned that we identified earlier. Keep in mind that that's part of our investigation, that we're looking into every aspect of that individual, his connection here at the school. Obviously, as I mentioned earlier, he was a student here. So as part of our investigation, we're looking into all aspects, current and prior, involving that individual.
Can you tell us how many rounds were fired? Can you tell us how many rounds were fired?
Do what?
The shooter is a student, yes.
When can we expect
We do not know how many rounds.
Has that shooter had any past history with law enforcement?
For now, this is the information that we have. It is an active investigation. I assure you we do plan to come back out here in a couple of hours. Please make sure you're following the GBIX page. That's where we're going to be putting the updates. If there's anything that's new, we'll make sure that we share that information. It's still very early. Investigators have a lot of work to do. We appreciate your patience. Do expect another in-person news conference out here in the next few hours. Monitor the X page, and we'll be sure to update you accordingly. Thank you.
And that's the X.com.
Thank you.
that was the press conference regarding the school shooting in Georgia. I have an update coming in just a couple of minutes. I will say this before I even get to that update. This case is going to be the Crumblies all over again. Now, why am I making that big a prediction? Stick around, you'll see. In the meantime, next up on the docket, Lori Shaver is preparing for her murder trial in one final hearing. Attorneys debate key issues in Lori Shaver's murder trial, including her daughter's alleged confession to killing her father. Now, I'm not going to play that video for you, but I will break down everything. I will give you everything in the case that is pertinent to it. Florida woman Lori Shaver appeared in a Lake County courtroom as attorneys debated motions that offered a preview of key issues in her upcoming murder trial for her. My phone's going off. 1 second. Okay, there we go. Now, let me try this again. Florida woman Lori Shaver appeared in a Lake County courtroom on Friday as attorneys debated motions that offered a preview of key issues in her upcoming murder trial for her husband's death, including her daughter's alleged confession to killing her father. Shaver is accused of shooting and killing her husband, Michael Shaver, in November 2015, burying him in the backyard of their Claremont, Florida home, and then impersonating him in text and Facebook messages to create the impression he was still alive. His body was found in March 2018, 3 feet below ground, under a concrete slab and fire pit that Lori installed in the backyard in 2016, according to a law enforcement affidavit. Shaver's defense claims that her daughter, who was 8 years old at the time, pulled the trigger and killed her father during a violent episode to protect her mother. The Shavers were living together but dating other people when Michael went missing. Lori's defense wants to present evidence that Michael allegedly subjected Lori to years of physical, sexual, and emotional abuse. Lori's defense claims in court documents that their 2 children witnessed much of the physical abuse, including an alleged incident on the day Michael was last seen alive that led their daughter to kill her father. Presiding Judge Carrie Rada limited the circumstances under which the jury could hear about those allegations, creating the possibility that at least one of the children may testify, most likely the daughter who allegedly pulled the trigger. The couple's troubled relationship and their daughter's alleged confession were among the topics that came up at Friday's hearing on several outstanding motions. I would love to go through all of this, but it's going to it would take a minute. But know that jury selection is scheduled for September 9, which is today. But I will go as far as saying this: how would a 7 or 8 year old know how to even operate a murder weapon, or weapon period? That's the one thing that still has me puzzled. How would an 8-year-old know how to operate a weapon? I believe Lori used that and said that her daughter did it just to, CYA. And anybody who knows what that means knows knows exactly where I was going in that particular statement. So I will be keeping an eye out to find out exactly what has gone down in that hearing, and we'll find out. Oh, excuse me, not that hearing. But jury selection starts today, which means this case is going forward, and we'll find out exactly what transpired on day 1 of Florida versus Shaver. In a trial going on right now in Florida, Cadell Piedrahita is facing a potential life sentence if he's convicted of killing a Florida bicyclist and threatening another. Road rage, anyone? The trial is underway for a man accused of murdering a bicyclist out riding with a group and threatening a second man. Cadell Piedrahita is charged with second-degree murder for the shooting death of Alexis Palencia and aggravated assault with a firearm for allegedly threatening Cesar Sosa during an incident on August 14, 2019. In court records reviewed by Court TV, investigators say that Piedrahita shot Palencia once in the stomach on the Rickenbacker Causeway before turning to Cesar Sosa, pointing the gun at him and yelling profanities. Sosa ran away from the scene and was not injured. Witnesses who told police they knew Piedrahita through their cycling group identified as the killer. Piedrahita was well known to the cycling group known as the Don Pan Riders because he would often ride beside them on his motorcycle to help protect them. That's according to the Key Biscayne Independent. Assistant State Attorney Arvind Singh told the outlet that there had been a dispute between the two men before the shooting involving insurance. Palencia either sold or brokered insurance, and Piedrahita allegedly blamed him for a lapse in his coverage. The confrontation was recorded, as Piedrahita had been live streaming the ride before the deadly shooting. In a statement after his arrest, State Attorney Catherine Fernandez Rundle said, "I have seen the video images of this incident, and I am extremely bothered by the images I saw." Piedrahita has gone through a number of attorneys in this case, and despite one of the attorneys alluding to a stand-your-ground defense to local media, no motions identifying that as a defense strategy were ever filed. Piedrahita wrote a letter to the court claiming he acted in self-defense. The letter obtained by the Biscayne Independent said he was a prisoner of a corrupt system and a victim of political and social manipulation and physical and circumstantial evidence. I had to use my legal, registered gun to exercise my second constitutional right to bear arms and protect my life. But first, after opening statements by both sides, two officers have testified to the scene, and testimony is continuing as we speak. So I will keep you updated on this particular trial as well. We had an update with Alec Baldwin earlier. Now we're gonna update on Hannah Gutierrez reaching a plea deal on gun charges not related to the Rush shooting. Hannah Gutierrez, serving time for involuntary manslaughter for the shooting on the set of the movie Rust, has reached a plea deal on separate charges to avoid further jail time. Gutierrez was indicted in November 2023 on a single charge of unlawful carrying of a firearm in a licensed liquor establishment, which is punishable by up to 18 months in prison and a $5,000 fine. Days before a scheduled hearing in the case, a new filing revealed that both sides had reached a plea agreement. The agreement, reviewed by Court TV, has Gutierrez pleading guilty to the charge. Under the agreement, she will be sentenced to 18 months of supervised probation that can be transferred to Arizona, where she has family. Her sentence will be deferred following the successful completion of probation. But if she violates the probation, she will be subjected to a year of parole. There are some special conditions outlined as part of her plea agreement, including that she cannot possess firearms or ammunition or live in a home where they are present. She cannot consume alcohol or drugs and will be subjected to random tests. She must enter and successfully complete any treatment or counseling deemed necessary by her probation officer. Gutierrez is still fighting her conviction and sentence for involuntary manslaughter and has argued her case should be reconsidered because prosecutors failed to share exculpatory evidence. No date has been set for Gutierrez's plea hearing. So while we're still waiting, she's still waiting for that. At least she can rest knowing the fact that that she can actually see herself not staying in jail for longer than what she's already been sentenced for the rush shooting, and hopefully she won't be staying in jail long at all for that. We'll see what comes of that. All right, back to the Georgia school shooting. This is where I made my prediction earlier. Remember, I just said moments ago that the way the school shooting has gone down, this is the Crumblies all over again. Well, here's why I say it. Authorities arrested the father of high school shooting suspect in Georgia. Here we go again. Trigger warning. Check. Copyright disclaimer. Set and ready. So here's that. I'm going to jump out of the shot, and we're going to go right back to Court TV for what was considered that day breaking.
All right, folks, I want to alarm you now to some breaking news from Georgia. The father of the teen shooting suspect from yesterday's deadly high school shooting has been arrested. 14-year-old Colt Gray is also under arrest for killing 4. Well, Gray's father, 54-year-old Colin Gray, is charged with second-degree murder and involuntary manslaughter. The shooter's father reportedly bought his son the AR-15 used in the shooting as a Christmas gift last year. He reportedly bought the gun after being questioned by sheriff's deputies for a previous school threat. 14-year-old Colt Gray is charged with murder and is being treated as an adult by the system. Again, 2 students and 2 teachers are among the dead. 9 others were injured. They're expected to be fine, so that's good news. Colt Gray will be in court tomorrow morning for his first appearance. All right, let's bring Alexis Rosenberg back in, federal trial attorney. Alexis, not a surprise. I've been saying all along, once there was this initial report last year that there might have been some issues, I said the father better watch out. But I didn't know the circumstances with the family, but now we're finding out that, in fact, after the police came to their home, talking about a possible situation where there were threats made to the school, they didn't arrest anybody, didn't have enough evidence. Apparently after, at least according to this report, he buys him this AR-15 style rifle, which was then used in the shooting. He is now arrested. Your thoughts?
I agree. I think he should be arrested. I mean, this is ridiculous. The FBI was even involved in the initial investigation as to the threats, and now and I believe that they advised that he needed to keep the guns that were already in the home locked up so the son didn't have access. To then go out and buy the son a firearm, I mean, it's just, that to me is insane. This is the worst nightmare of any parent who has school-age children. So I think this was the right move, and I'm glad that the system is moving towards holding these parents accountable.
That's interesting, because that's what I was going to ask you about, that move. You know, we saw what happened in Michigan, clearly, convictions there. Again, we don't know what the background of this young man is. I think a big thing in that case in Michigan was this idea that there were plenty of signs. Now, I agree. I think holding parents responsible under these circumstances is important, but do you agree that there would need to be some sense of there was a problem with this child? Because again, this is America. Buying guns for young men in certain parts of this country is just a rite of passage. You don't want to criminalize that. But again, I would imagine there may have been some issues there that they should have been aware of.
I'm not licensed in Georgia, and I definitely am not a gun expert in the state of Georgia, but I would assume that there's a law that a 14-year-old cannot go out and buy his own gun for himself. So I think that there has to be some accountability. And like you said, in this specific case, there was notice. There was some sort of notice. There was an investigation that he was possibly connected to that previous threat, even though it ultimately there wasn't enough evidence to substantiate charges being brought.
Yeah, now the father, when the police talked to him, he said he never dealt with, the child was never allowed to deal with guns. He admitted to having plenty of guns in the house, but he said that his son was never allowed to use them unsupervised. Apparently, he bought this gun for his son. And the son then, I guess, took it and did this with it. Ultimately, again, it probably wasn't locked up. So under those circumstances, I would agree. I think, at the end of the day, there has to be this sort of, accountability on the part of the parents. But finally, quickly, he's being treated as an adult. The young boy, Colt Gray, is. Do you agree with that? They made that announcement yesterday. It kind of bothered me. I don't know how much they knew about him at the time, but already announcing he would be treated as an adult, I guess affected me a little bit as a defense attorney. Your thoughts on that?
Well, I think I'm going to get some comments for this because I have in the past, but I have a personal problem with children being charged as adults. I personally think, especially when this is so far, we don't have a 17-and-a-half-year-old here.
All right. Well, just going to keep following the developments in this case for sure. Alexis Rosenberg, thank you so much for being with us tonight.
Yeah,
Truly appreciate all your insights. I'm Michael Ayala. It's been a pleasure being with you. Thank you so much for being with us.
Special thanks to Court TV's Michael Ayala and defense attorney Alexis Rosenberg for their input on this. And like I said, this case is going to end up being another version of the Crumblies all over again. And first you have the 14-year-old who shoots and injures 9, kills 4, allegedly. And now the father is arrested. He is being brought up on charges of involuntary manslaughter for merely buying the weapon that was used in the shooting. If you look at it from where my predictions coming in, I said that this is the same thing with Ethan, who shot up his school for succumb to their injuries. Many others were injured, and then you got the parents. They've been they're busted for involuntary manslaughter, and they're doing time in jail too for pretty much enabling what happened with Ethan. So the only thing, the more things change, the more things stay the same. The only difference is this one's in Georgia. We wait and see what occurs next. And in fact, Julie Grant, if I can pull that, I'll probably pull it up sometime this week. Oh wow! There are new details revealed in the investigation into the deadly shooting at Appalachian High School in Georgia. They're saying that the mother of the suspect called the school before the shooting. Is she at fault too? So that's two videos I'm gonna have to look up. When I do, I'll let you guys know what I find out, what I can show, what I can't, and we will see exactly how it all ties in. Speaking of Julie Grant, she has a quick update on Bryan Kohberger looking to strike the death penalty from the case. Kohberger's defense filed over a dozen motions seeking to strike aggravating factors and the death penalty itself. So I'm going to set this up right here like so. Now, sure, this is only yeah, good. I'm already ahead of the game. Now, sure, this is only what, a quick 39-second update, but it's important if you are following the Bryan Kohberger case, like a lot of us are. So, give me just 39 seconds of your time. I'll take you to Julie Grant, and she will update on what's been filed and anything else possible regarding Kohberger.
So we have some breaking news just coming in. Attorneys for the man accused of killing 4 Idaho college students are now seeking to remove the death penalty from his case. Prosecutors have said they intend to seek the death penalty for Bryan Kohberger if he is convicted. The defense argues, among other things, that Idaho's system of obtaining death convictions is unconstitutional at this time. There's going to be a hearing on this matter set for November the 7th. Kohberger is accused of murdering Kaylee Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin last November in Moscow, Idaho.
And there you have that. There you have that. Thanks to Julie Grant. We'll see exactly where this will, which way this will go. But for right now, the document, those documents also claim the means of which the death penalty are carried out in Idaho are unconstitutional, saying, quote, executing Mr. Kohberger by means of lethal injection or a gunshot, as conceived by the Idaho Department of Corrections, would violate his right to be free from cruel and unusual punishment under the 8th Amendment and his due process under the 14th Amendment of the United States Constitution. Other documents claim Idaho's death penalty violates international law and human rights, and that there has been an ideological shift in the United States, and that the punishment now violates our contemporary stands of decency. Kohberger's defense also claims Idaho's statutory and constitutional guarantee to a speedy trial prevents effective assistance of counsel in death penalty cases, and a capital case cannot be prepared in 10 months. His trial is set to begin in June 2025. For months, Kohberger's attorneys have been fighting to have his trial moved from Latah County to Ada County, where Lori Vallow and Chad Daybell stood trial. Following a hearing, Judge John Judge is currently weighing the decision to move the trial. Excuse me. According to court records, Judge John Judge will hear arguments on the challenge to the death penalty on November 7. And Bethea'S Byte Reloaded will be covering that as well. One more update regarding the Georgia school shooting. Bail? What bail? Neither 54-year-old Colin nor 14-year-old Colt asked the judge for bail when they appeared for the first time after the school shooting. I'll put up the copyright disclaimer again, and this time I don't even need to read the article. You'll get to see the hearing for yourself. Both Colton and Colin at a bail hearing, neither one of them asking for bail. Here's your copyright disclaimer right there. I'm getting out of the shot.
Thank you, and please be seated.
And good morning, everyone. My name is Curry Mingeldorf. I'm assigned to preside over this morning's proceedings. We're here for a limited purpose this morning. I do want to note for everyone's benefit that there is, as everyone certainly is aware, considerable interest in what has occurred in our community in the last several days. For that reason, the court has seen fit under Rule 22 of the Uniform Superior Court rules to allow media outlets to record some of these proceedings. However, under those rules, the court has set in place certain limitations, and I just want everyone to know that the media has been informed of that, and I'm confident that they will comply with that. But otherwise, there is to be no filming or recording by any members of the public or any other individual other than those authorized specifically by the court in its signed ruling. Are we ready, counsel, to begin and bring the defendant in?
State's ready, Your Honor.
All right.
Defense is ready.
All right. All right, good morning, sir. Are you Mr. Colt Gray?
Yes, sir.
My name's Curry Mingeldorf. I'm assigned to preside over this morning's proceedings. Mr. Gray, I do need to inquire as to whether you're able to read and write the English language.
Yes, sir.
All right. I also want to inform you, I want to ask you, do you understand that you have the right to be represented by an attorney in these proceedings?
Yes, sir.
And you are, in fact, represented today, is that correct?
Yes, sir.
And Mr. Zane Harmon, you're here on behalf of this defendant, is that right?
Yes, Your Honor.
All right. And you understand that you have the right to be continuously represented throughout this proceeding, and if you cannot afford to hire counsel, then this court is obligated under the Constitution to provide counsel for you without cost to you. All right. I am going to inform you of a few other matters, and I'm not going to ask you anything, just inform you. So one is, I want to make sure that you are aware that you have the right to remain silent. You don't have to say anything at all. And it's important to understand that because anything you might say could be used against you at further proceedings associated with your case. I want to inform you of the charges that you currently face. In essence, you are charged with 4 counts of felony murder, as outlined in the state warrants that have been issued against you. I want to make you aware that the maximum penalty for felony murder, so for each count, the maximum penalty is that you could be punishable by death, by imprisonment for life, without parole, or by imprisonment for life, with the possibility of parole. If you have any questions about these charges, then I would urge you to discuss those with your attorney. I would invite you, Mr. Harmon, to inform the court as to whether there's a request for bond at this time.
At this time, Your Honor, there is not a request for bond. We will file the appropriate motions if that becomes necessary.
All right. An indictment by the grand jury for most felony offenses or accusations, well, you have the right to receive an indictment for these offenses. And I assume Mr. Brad Smith is here on behalf of the DA's office, or he is our district attorney, and he's accompanied by Ms. Patricia Brooks, who is his chief assistant. A preliminary hearing, you'll have the right also to a preliminary hearing, unless you make a bond, which of course at this point there's no bond being requested, or unless you waive such a hearing. You have the right to a speedy and public trial by a judge or jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. As you sit here in this courtroom today, under the law, you are presumed innocent. Your refusal to testify at any point in any proceeding will not be used against you in determining whether you are guilty or not guilty. Counsel, let me just inquire as to whether there are any other items that the court should address before we conclude this preliminary hearing.
No, Your Honor.
There you are.
Well, I do have one piece of information to convey to the court. There was a development yesterday afternoon that makes it necessary for our office to have alternate counsel appointed, and arrangements have already been made in that regard. I've already explained that to Mr. Gray, and alternate counsel will be appointed by the end of the day today.
All right, thank you very much, Ms. Donna C. Graves. All right, then with that, this hearing is concluded, and you may escort this defendant out. Good morning, sir. Are you Mr. Colin Gray? Am I pronouncing your first name correctly? Mr. Gray, my name is Curry Mingledorf. I'm assigned to preside over this morning's proceeding. This is your first appearance hearing. And at this hearing, I'm first going to ask you just a few questions, and then I'm going to advise you of your rights and also let you know about a preliminary hearing that's been scheduled for you. Why don't you just state your name, please? All right, pull the microphone down, please. There you go. All right, and how old are you, Mr. Gray?
54.
And are you able to read and write and understand the English language without any difficulty?
Yes, sir.
How far did you go in school?
11th grade GED.
Okay. And I note that you have counsel seated with you at the table. You understand that you have the right to be represented by an attorney at all times for this and all future proceedings in your case?
Yes, sir.
And you understand that, of course, if you cannot afford an attorney, that the public defender will be appointed to represent you upon your request?
Yes, sir.
All right. And counsel, would you identify yourself, please, for the record?
Donna C. Graves. We are going to have new counsel assigned to Mr. Gray later today.
All right. Thank you. All right. Okay. Sorry. Just need to make sure that the system is working. And all right. So the following aren't questions that I'm going to ask. I'm just informing you of some things. You have the right to remain silent. Anything you say can be used against you at further hearings or at a trial on the charges that you're facing. For this hearing, you're not going to be questioned about facts and circumstances surrounding your charges. You are currently charged with, and you'll be provided with copies of the warrants if you don't already have them. You're currently charged with 2 counts of felony murder in the second degree. You're charged with 4 counts of involuntary. You're charged with a felony cruelty to children in the second degree. Now, for these offenses, for the felony murder counts, in the second degree, felony murder in the second degree, the maximum penalty for each count is up to 30 years imprisonment. For felony involuntary manslaughter, of course, again, there are 4 counts. The maximum penalty for each of those offenses is 10 years imprisonment. For the 8 felony cruelty to children counts, the maximum penalty under the law for each of those 8 counts is 10 years imprisonment, for a maximum total possible penalty for the charges that you currently are facing of 180 years imprisonment. If you have questions about these charges, which I assume that you will, the court urges you to discuss those with your attorney. Let me inquire as to whether there's a motion for bond if Mr. Gray is moving for bond at this time.
No, sir, not at this time. We will allow alternate counsel to make that decision.
All right, thank you. I also need to inform you that you have the right to an indictment by a grand jury, and you also have the right to a preliminary hearing unless you make bond or waive such a hearing. You have the right to a speedy and public trial by a judge or jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. I want to make it clear to you, Mr. Gray, that you are presumed innocent. Your refusal to testify at any point cannot be used against you in determining whether you are guilty or not guilty. I mentioned the first appearance hearing a moment ago. That is being set for you for December 4th, 2024 at 8:30 a.m. Currently that's set to take place in the Magistrate Court of Barrow County. It could be subject to change, but I just want you to know that that is the date that we currently have. In fact, counsel, could you approach, please? I have this, let's see, I need to scratch this out.
Okay, and the signal is freezing up a little bit there. Something totally out of our control, but we're going to continue watching it. So we've got Colin Gray, 54 years old, the father of the Georgia school shooting suspect, Colt Gray, said by authorities to have known the dangers with his son and yet still provided him with a semi-automatic rifle that they say was used to carry out that massacre in which 4 people were killed, 9 others injured. Here are the 4 deceased victims, 2 students and 2 school teachers. Now, this hearing is what's called an arraignment. This is the first arraignment that any criminal defendant will have after their arrest. This is a quick appearance where you hear they're advised of their rights. The judge asks them if they can read, write, understand the English language, understand the charges against them. The judge informs them of the charges, what they are, and then asks their position on bond. And in both of these cases, neither one of them has requested a bond. I would say that's a very smart move. We're going to get back into the courtroom in just a moment. Stay with us. We continue our breaking news coverage this morning. I'm your host, Julie Grant. Thank you for watching Court TV Live. We're witnessing history this morning. Let's let this sink in because we have another parent being accused of criminal liability in the actions of their child in a school massacre. We saw this first in Michigan, and we watched 2 trials playing out for James and Jennifer Crumbley because of the actions of their son, Ethan Crumbley, and the murders he carried out at Oxford High School. Now, today, we're seeing even more history as that landmark case in Michigan has now paved the legal road to have more cases like it. And now, sadly, here we are with an eerily similar prosecution of a parent providing their dangerous child with a firearm, even when they are said to have known the dangers. That is the allegation for Colin Gray, who is the father of Colt Gray, the Appalachia High School shooting suspect. The kid just transferred to the school 2 weeks before this incident, where he is said to have murdered 4 people and seriously wounded 9 others. Thank goodness those 9 others are going to make a full recovery per the local sheriff. And this morning, these 2 are both being arraigned in criminal court. Colt was arraigned at 8:30. He's being tried as an adult per Georgia law. And now it's Dad's turn. We had a little bit of an interference with the signal moments ago. It's repaired. Let's return to the courtroom now.
This document discusses bond and gives the date of the preliminary hearing, and I guess I could sign that, and he can just get a copy of it. And then the warrants are attached to that. So And I would like for him to sign it. Please.
Sign right there, just saying you're getting a copy of this. He is giving you a copy. He's going to give you a copy of all the warrants, too. Do you want me to give him his copy? And the page contains And are these his copies of the warrants?
Those are provided, and they say service copies on them, so I assume that they're for him. Sergeant Briscoe, do you concur with that? Is that what those copies are for?
That's the detention center.
Those are for the detention center? So he's got his own copies, or he'll have them provided? All right, so the detention center wants to hold on to those. All right, let me, and thank you, Missy Graves. I want to certainly acknowledge the presence of our district attorney, Mr. Brad Smith. He's assisted by his chief assistant, Patricia Brooks. Is there anything else, counsel, that the court needs to address that I have neglected to address?
No, Your Honor.
No, sir, not at this time.
All right. I do want to thank those who are in the gallery who have an interest and who have appeared. I appreciate the decorum that has been maintained throughout this proceeding, or both of these proceedings today. And with that, this matter is adjourned.
The attorney who's going to represent you, I think his name is James Rogers. We're going to have the official later today, but he'll come and see you probably the first part of next week.
Okay.
First off, another thank you to Julie Grant for guiding us at that point where the stream had frozen. Both father and son charged. Both father and son asking at the time for no bond. Here's the breakdown, real quick. Colt Gray arraigned on 4 counts of felony murder 2 days after being taken into custody for the shooting at Appalachian High School in Winter, Georgia. The maximum penalty for each count is punishable by death, life without parole, or life with the possibility of parole. Despite his age, he is being charged as an adult. His father, 54-year-old Colin Gray, arraigned on 4 counts of involuntary manslaughter, 2 counts of second-degree murder, and 8 counts of cruelty to children. The maximum penalty for all the charges is 180 years in prison. Guys, this is what I was talking about. This could very well be a Crumbly case all over again, but this time in Georgia. Let's keep a watch on this case, and I'll bring the updates to you, as always. Next. The husband of a missing Virginia nurse is heading to trial in early 2025. Naresh Bhatt waived his right to a grand jury proceedings, paving the way for him to head to trial by early 2025. When Mamta Kathleen Bhatt disappeared in late July, members of her local community in Northern Virginia and her family in her native Nepal banded together to try to figure out what happened to her. They posted on social media, hosted community events, and held a rally for the 28-year-old mother and pediatric nurse. Within days of her disappearance, community members began to apply public pressure on her husband, Naresh Bhatt. My friend called me and said, "What do you think?" And I said, "Let's talk about it." So we initiated a group chat, and then the movement started. Said Bina Katkalama, a member of the local Nepali community in Northern Virginia. Bhatt was arrested about 3 weeks after his wife disappeared and charged with concealing a dead body. A prosecutor later said in court that the amount of blood found in Bhatt's home indicated injuries that were not survivable. Though his wife's body remains missing, Naresh Bhatt waived his right to a grand jury proceedings on last Thursday, paving the way for him to head to trial by early 2025. The trial date is expected to be set during Bhatt's next hearing in Prince William Circuit Court on September 16th, which is next week. Prince William Deputy Commonwealth's attorney Matthew Sweet described the waiver as a tactic move by Bhatt's attorneys that limits prosecutors' time to build their murder case, a process that typically takes longer than 6 months. We have multiple agencies, multiple witnesses who are out of state, out of the country, that we have to prepare for, Sweet said in court. Chief Public Defender Tracy Lennox argued that Bhatt was still entitled to a speedy trial, despite prosecutors' wish for more time, adding that his defense couldn't control whether the arrest was premature. They chose to charge in this, Lennox said, adding, "I understand the inconvenience to the Commonwealth, but this is where we are." On last Thursday, the Manassas Park Police said they were searching for evidence in the investigation at a nearby school, multiple parks, and other community areas. The investigation has drawn international attention to the small Northern Virginia community where homicide cases are rare. In the courtroom, more than a dozen community members sat among the benches wearing pink pins printed with Bhatt's face. "We're always thinking about her. We're doing so much here," Kat Kalana said. "The case is a 24-hour topic for us. I go to work, I drive home, I think about Mamta." Holly Worth, a nurse who used to work with Mamta Bhatt, has been vocal in the case. Hoping to gain accountability for a friend, she described Naresh Bhatt's waiver of grand jury proceedings to be legal gymnastics, but said she believed prosecutors would still have ample time to prepare this case or other charges that they could be pursuing. "Mr. Bhatt thinks he's smart, but I guarantee you the weight of justice is leaning hard on him, and we're going to see this come to fruition." I'm waiting to see what's going to occur next. How deep is this going to go? So we'll just wait by early 2025. I don't know when exactly that'll be. I'll keep an eye on this, and I will bring the information to you as always. Let's see. Okay, I believe I've covered just about everything. And this is my last story on the docket. We have newlyweds charged with the murder of a groomsman hit by an SUV out of Flint, Michigan. A newlywed couple has been charged in the death of groomsman who was struck by a vehicle on the wedding day. That's according to authorities in Michigan. Excuse me. The groom, James Sherrod, was at the wheel when the SUV hit Terry Taylor Jr. in Flint on August 30th, according to police. After the wedding, Taylor was involved in an argument which led to him being intentionally struck by a large SUV that was traveling at a high rate of speed. 22-year-old Shara was charged with second-degree murder. The Genesee County Public Defender's Office Thursday said that an attorney hasn't been assigned to the case just yet. Police described 29-year-old Taylor, as a groomsman. I've never seen anything quite like this, David Letton, who was in his 20th year as a county prosecutor, had said. I've seen people running over other people, but not so soon after a wedding. Layton, citing the police report, said the wedding was at a pizzeria. The argument occurred at a house where the celebration continued. Taylor was in the street in front of the house when he was hit by the SUV, Layton said. The bride and groom left the scene and didn't go to police until the next day, he added, making it more difficult to unravel what happened. Shiraz was being held in jail without bond. His 21-year-old wife, Savannah Collier, was charged with being an accessory. She also posted bond. That's one of those cases that's gonna make you go, I need more information. And in my case, I always need more information. So we're gonna find out what becomes of that as this case grows, goes to trial, and eventually we'll find out what happens at the end of that. Oh, we have a couple of verdicts we've got to get through before we end this thing. And one last Sarah Boone update. So I'm gonna get to that first before we go to those verdicts. It is official. Sarah Boone will use the battered spouse syndrome defense. I'm going to take you to Michael Ayala for this piece of breaking news.
Folks, we have some breaking news just coming into our newsroom. We found out that the suitcase murder trial going on in Florida involving defendant Sarah Boone, well, she has officially filed her notice of intent to use the battered spouse syndrome. Boone claims that her boyfriend Jorge Torres abused her. She's charged with second-degree murder in his death. And remember, he was found inside a suitcase zipped up. Boone initially said it was a case of hide and seek gone wrong. Well, Boone's trial is scheduled to begin next month. We will continue to follow developments and bring you the latest.
very simple reason. The jury heard all of the evidence. The jury evaluated all of the evidence. The jury came back with a first-degree verdict, which was the correct verdict. It was a verdict that, when you look at the totality of all that happened during this particular crime, it's the only verdict a reasonable person could come up with. And considering all the evidence, and I'll just hit a few high points that I think, honestly, the jury was looking at. The defendant's text message to his cousin about killing. Defendant's controlling, demeaning behavior. And he said just a few minutes ago, he wants us to know who he is. That's who he is. It's very clear from the videos. His driving over to the apartment with a loaded gun. The fact that the victims were helpless, completely taken by surprise. The planting of a listening device. Firing within seconds of entering the apartment. Clearly showing an intent to kill. Not heat of passion. Willful, deliberate, premeditated, cold-blooded murder. And something that is hard to explain. Ray was not involved in their problems at all. But he shot Ray first. Shot him in the head. In an attempt to kill. You don't shoot people in the head unless you want to kill them. And in front of Anna. That was deliberate. He wanted her to see it. Very cruel. He took photos immediately afterwards. Who does it? Calls his mother. He had 3 days on the stand to explain his actions. He explained it. And the jurors came up again with the only reasonable verdict, which is a first-degree verdict. They also found, because there was 2 deaths, that this was multiple murder. In Penal Code Section 190.283. The next thing this court has to consider is the gun enhancements. In the state of California, the legislature has, both slowly and quickly, changed certain enhancements. And the court is obligated to look at reducing certain enhancements, including those that require or have a 20-plus year addition to the sentence. And again, I look at both mitigating and aggravating factors. Of course, it goes without saying this crime involved great violence, it involved a firearm, it involved vulnerable witnesses, victims who, again, had no time to react, no time to defend themselves. It involved planning. I don't think you could say it was sophistication or professionalism, but it certainly involved planning. When you load a gun, arm yourself with a gun, drive 10 or 15 minutes to an apartment complex. As we saw on video, his demeanor going up the elevator, his demeanor going down the elevator, that showed planning. And obviously it was he took advantage of a position of trust. Clearly. And she didn't know he had a key, but he took advantage of that. Now, there are certain factors that, as for mitigating factors under the rules of court, I don't find any. Zero. None. There are certain factors with the defendant that I am obligated to take a look at. I acknowledge he has no prior record. I acknowledge the fact that at the time of this killing, he was suffering substance abuse and had some mental health issues. But I reject the fact that his childhood contributed to this at all. I hear terrible childhoods day in and day out. And his was not ideal, but it wasn't what we hear in this particular court. And I don't think that any of these crimes were connected, in fact, to his mental health or even his substance abuse. He was over 26. It did involve intimate partner violence, but he was the one that was committing the violence on her. And of course, he denied when confronted with it what happened initially. So the court is not going to strike or reduce the gun enhancements. The question then becomes one of whether or not these life without possibility of parole should be consecutive or concurrent. And that's a big deal. That will, in all likelihood, determine whether or not he dies in prison or out of prison, whether he dies a free man or one who's not. And this is the bottom line on this, is I've watched him here during all of this time. He's a very talented actor. He is a very talented actor. When I saw the Scarface videos, it's as if when he committed these crimes, he became that persona of Scarface. Just cold-blooded killing without remorse. Any tears that he's cried in this courtroom have been for himself. They are not for Ray and Anna. It's just, that's the reality. He fears the consequences, as he should, of his actions. But as he sits here today, I don't know if he's really sorry. I have serious reservations about it. I know he's sorry about the consequences of going to prison for the rest of his life. But I can't say that I think he's sorry for having killed these two innocent human beings. He's a very selfish person, as I think the jury saw. That was something that his character kind of came through when we asked, who is Alec Abulaban? That's who he is. He's somebody that is only thinking about himself, and the idea of killing two innocent people doesn't disturb him. It's killing. So the bottom line here is he will die in prison. He will never be a free man. He will take his last breath. In this matter, the defendant on count 1 will be sentenced to life without the possibility of probation via Penal Code Section 1190.2, Parent A, Parent 3. Consecutive to that will be 25 years to life on the gun enhancement under Penal Code Section 12022.53D. Consecutive to count 1 will be count 2, which will be life without the possibility of parole. Penal Code Section 190.2, Parent A 3. Consecutive to that will be gun enhancement of 25 to life under Penal Code Section 1222.53D. Total prison term, 50 years to life plus Outlaw. Life possibility of parole. He's given the following custody credits: 1,552 days. He is given the following fines and fees.
Your Honor, probation has credits of 1,052 as of today.
Okay, 1,052. He will pay a restitution fine of $10,000 under Penal Code Section 1202.4B. Court security fee of $80 under Penal Code Section 1465.8. Criminal conviction fee of $60. The general order of restitution. Today's time will be set at, for the funeral expenses, of $12,890. And what was your other restitution amounts?
Just so the record is clear, that $12,890 is to the Victim Compensation Board.
Correct.
The amount to Amalia Miller is $3,000 $324.24.
We can cancel that this time. Go ahead.
I can't. Please don't interrupt. Go ahead.
And the amount to Hermé Sarton is $1,214.66.
All right. Those amounts were also. All right. Thank you all.
Your Honor, may I just want to make one clarification. When the court announced the sentence, 50 to life plus Outlaw, is that plus 2 terms of Outlaw, one for each count?
As I indicated, the counts 1 and 2 on Outlaw, under the special circumstances alleged and pled and proven under Penal Code Section 190.2, parent A, are consecutive to each other. That's 2 consecutive Outlaw terms, plus on each count, 25 to life, totaling 50 to life, plus Outlaw. So yes, they are consecutive to each other.
Thank you.
Yeah. All right.
And there you have it. Ali Abulaban set to spend the rest of his life behind bars for the murder of his wife and his best friend. 2 consecutive terms. Nah, he ain't getting out of nowhere. He's not getting out. And Amy, you saying you would have loved to see his reaction? Oh, I bet you would have. I bet you would have. Prior to the sentencing, he was actually crying. Well, I don't know how legit the tears were, but he was crying. Bryan, he was reading from a paper as he addressed the court during the sentencing, but the judge, he like I said, he had no sympathy for Ali, who was convicted of first-degree murder for shooting his wife Anna and her friend Rayburn Barron. Bottom line, that's justice served. And speaking of justice served, I've got one last sentencing to go through before I wrap this edition of Bethea'S Byte Reloaded up. This is the tattoo punch murder defendant being sentenced here. Kevin Sehmer found guilty of murdering a man with 1 punch, all because he didn't like the guy's tattoos. Said the guy was going to hell because of his tattoos. Well, let's see what the judge has in store for Mr. Sehmer.
In this case, the court will sentence the defendant as follows. I will impose a 12-year period of imprisonment, 7 years of initial confinement followed by 5 years of extended supervision. The court will order costs to be paid by the defendant, and my clerk will tell me what that amount is in a moment.
$518.
The court will require conditions of extended supervision, which includes absolute sobriety, no possession of any alcohol or consumption, and the defendant, when on extended supervision following his service in prison, will test to verify his sobriety. The court will provide credit to the defendant for his service in the Waukesha County Jail. Mr. Shiro has offered 428 days. What is the position of the state?
Close. We came up with 423. He only spent 2 days in custody during that first stint, according to our records from June 18th and then released on June 19th.
I'm getting this. He's assistant. She was June 13th.
It didn't happen until the 17th.
She have there. So you have 2 days?
2 and then 421, so 423.
Okay.
Court's going to indicate 423 days of credit. The judgment of conviction will not be signed for probably a couple of days, so if there's an issue or dispute regarding that, you can submit a letter, but that will be what I will indicate on this record today. The court will require that the defendant comply with all programming offered by his and required by his agent when he's on extended supervision, and sign any releases of information. There isn't a lot that I can do in terms of community service structure. Drunk drivers, frankly, we have a much more impactful manner, but in a way, this is reflected by this event by what I believe is the defendant's consumption of alcohol. So the court is going to require the defendant's attendance at a victim impact panel when he is on extended supervision, because I believe it at least would provide some observation of the trauma and impact on victims. Molly, you have anything? Anything else from the state?
No, sir, thank you.
Anything else from the defense?
Judge, I played the video, so I'm going to move it into evidence. Oh, which one? This one? Okay. Because it has to be recorded.
So it's not an evidentiary hearing, but you're asking me to have it in the record?
Yes.
As part of the sentencing?
Yes.
Is there any objection?
I just have a question. Is it saved in the Brighton format that you played it in? Okay, thank you. No objection.
All right.
No number where.
It's going to be placed as a thumb drive in the sentencing hearing portion as exhibit, what are we up to? Exhibit 1 for this hearing.
Thank you.
Well, that's it for Kevin Sehmer. He is given a 12-year sentence with 7 years of initial confinement, so he'll have 7 years behind bars, followed by 5 years of extended supervision, supervised probation. In that time, he must remain sober and submit to testing every week, and was given 423 days credit for time served. Well, I'm gonna put a question mark on the words justice served, because we'll just have to wait and see whether Sehmer will actually be a changed man from this. But right now, like I said, I'm just gonna keep a question mark on the words justice served as far as Kevin Sehmer is concerned. Well, that's it, ladies and gentlemen. That's a wrap for Bethea'S Byte Reloaded. Thank you all so much for joining me here. I wish I could have did this on yesterday, but things happen, and again, I apologize for it. What in the world's going on here? There it is. That's probably what that issue was. Okay. But anyway, we'll have to come back again. Let's do this all over again, and just remember where you are, ladies and gentlemen. This is the home for true crime news without the drama, where your opinions matter, lively debates are encouraged, your voice is heard, and above all else, just like we've seen with a couple sentences today, justice served. That's what we're all about here. Here, this is Bethea'S Byte, and yes, oh yes, it's reloaded. Thank you so much for joining me, Amy. A pleasure as always. I'm Ernest Bethea, the last outlaw. Thank you all so much. It's you to help keep this thing running. I can't express that enough. So let's rev this thing up again on next week, hopefully this weekend, and let's see what we find good and coming out of the courtroom this week. All right. Until next time, you guys know what to do. Bite this. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe to the channel, and drop me a comment on this video. Also, be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.